Welcome to this fourth lecture covering Chapter 5, which is the chapter in our textbook in which we discuss pleadings. So let's go forward to the material that we were on, or that we were about to go into. You may recall when we were last together, we talked about damages and the various types of relief that the plaintiff can seek and how that is described in the complaint. We talked about both equitable and legal remedies. And now we're going to talk about provisional remedies. Provisional remedies are a subset of that category, the equitable remedies. Let me go ahead and make this a slideshow. So when we see provisional, we're talking temporary. And provisional remedies reflect the fact that from the time that the lawsuit is filed until the actual trial can be many months, even years. In fact, it's probably about 18 months typically in federal court from the time that the lawsuit is filed until you actually go to trial. If something is in play that whatever is happening is going to continue to evolve over that period of time. And it could be that at the end of the 18 months, whatever it is that the person was seeking to get to accomplish the lawsuit, it's really too late to accomplish that. Imagine for a second that I believe that I own a priceless Monet, and Bob actually has possession of the priceless Monet. He is threatening to burn it. He has possession of it, maybe even has an arguable legal claim to it. If he burns it up before we actually have our trial in 18 months, there's no way that the court can kind of recreate that priceless Monet. Claude Monet is dead. He can't make any more. And so I can't get what I really want out of the transaction. It is true, if I'm successful, I could successfully sue Bob for the value of the Monet, but I don't want money, I want the Monet. Or it could be that Bob doesn't have the kind of money to pay me for the Monet. And so under those circumstances, that 18-month delay can be the difference between me getting what I want and what I feel I'm entitled to and me getting nothing. So the fix for that would be a provisional remedy. It would be me going to the court and saying, Your Honor, we just can't wait for 18 months. We need a solution now, at least a temporary solution. And so the way to go about doing that is through the injunction process. And we're going to talk about TROs, preliminary injunctions, and ultimately permanent injunctions. So the first thing that I do as the plaintiff is I'm going to request a temporary restraining order, which is more commonly called a TRO. And this is, when I request this, I'm requesting that the court file a document that temporarily restrains the other guy from taking some sort of action. In this case, it might be destroying the Monet. Usually this is done in kind of an emergency mode where people don't really have a lot of time to prepare. Maybe Bob has already threatened to burn the Monet. I don't know when he's going to do it. So we can't schedule something in 7 days or even 2 days, because Bob may take that date as a sign, oh, I need to be sure to burn this Monet before that particular date. And so you are typically going to have the issue of a TRO raised without a formal hearing, and sometimes without even notice to the other side. You try to give notice to the other side, but sometimes it's not possible to do so, and so it may just be the court hearing from one side. When the court hears from only one side, we call that ex parte. Usually ex parte community, well, they're always highly discouraged. But this is one of the few times where the court will actually entertain an ex parte request when things are super, super urgent. Now, of course, in order for the court to grant a TRO under these circumstances, it's aware of the fact that it's hearing from only one side, and there may be all kinds of facts and information that is not either available to the side that's requesting the TRO, or that the side that's requesting the TRO is not sharing with the court. And so the court is obviously disinclined to grant it because he's only hearing from one side. In order to be successful in a TRO, the side requesting is going to have to show, number one, they're probably going to win at the end. And number two, if they don't do, if the court doesn't do something now, something unrecoverable will be lost. You can't fix it later on. Both of those are pretty high hurdles for the person requesting the TRO to advance. So it could well be that the plaintiff loses its request for a TRO and ultimately wins at trial. That is not inherently inconsistent. Usually a TR is just going to remain in effect for a few days. I think the textbook says 10 to 14 days. In my experience, it's sometimes even less than that. It's just enough time for the other side to get up to speed with the facts, and where you can have a hearing where both sides are prepared and able to present evidence and able to talk about the law. And then at that point, the court has to, if the court has granted the ex parte TRO, then the preliminary injunction is what is now being considered. And again, and this injunction is going to last much longer. It is going to last actually until trial. So typically it's going to last months, in many cases even a year long. So it's a more significant decision. It has more significant implications to the parties. And so usually those hearings last quite a bit longer. And it could well be that the court enters the TRO but denies the preliminary injunction, perhaps because of information that is presented by the side that wasn't present for the TRO. And of course, at trial, the preliminary injunction can become permanent, meaning that that injunction is going to stay in effect essentially forever, or at least for the indefinite period of time. Let's talk about the issue of attorney's fees. By the way, I guess I should have made this clear. Provisional remedies can be sought in the complaint. I would say that usually you're going to file a separate motion for a TRO. You're certainly going to, as a given, you're going to file a separate motion for a TRO, but it's certainly something that could be raised in the complaint, but would not necessarily have to be raised in the complaint. Let's talk about attorney's fees. Let's first of all talk about the American rule and the English rule. The American rule is that both sides pay their own attorney's fees. That's the presumption in our system. The English rule is the reverse. The English rule is loser pays. All pay. We'll say this is all pay. Both sides pay their own attorney's fees. In England, the rule is loser pays. There's advantages and disadvantages to both systems. The English would say that the loser pays system discourages frivolous lawsuits, because anyone who's thinking about filing a lawsuit thinks to himself, well, if I lose, I'm going to pay my own legal bills, but I'm also going to pay the other sides, and maybe they've hired some fancy schmancy attorney, and so the bill is going to be very high. I have to be sure I'm going to win before I take that risk. And so that discourages frivolous lawsuits. Another argument is it seems fair. I mean, after all, the defendant, especially if the loser is the plaintiff, the defendant didn't ask to be sued. So why should the plaintiff be able to sue somebody, then not win, so therefore didn't have the best case, and the defendant is now out a significant amount of money? So there's both the concern about frivolous lawsuits and the concern about equities, the fairness of the circumstance, especially for the defendant. But the American system is that each side pays its own bills as a usual rule. The idea here is that while the loser pays system has some advantages, it also has some disadvantages. And the primary disadvantage is that while it discourages frivolous lawsuit, it perhaps also discourages meritorious lawsuits, because after all, when you're being sued, or excuse me, when you're the plaintiff and suing, you don't really know whether you're going to win or not. I mean, obviously there's going to be a jury that's going to determine that case, and by definition, you can't be certain you're going to win. And certainly having to pay your own legal bills and the other guy's legal bills after you lose can be financially devastating. And so it can cause cases that really perhaps should have been sued not to result in litigation. And as a result, some people say American lawsuits are more common in part for that reason. So that's the usual rule. And so this is the American rule. There are some exceptions to the American rule, and that is statutory legal fees. There are times wherein the attorneys will, excuse me, when a statute provides that the attorneys, for example, the loser will pay the attorney's fees. That's especially true when the loser is the plaintiff. When the loser is the defendant, usually the plaintiff is not required to pay the legal fees. Then there's, again, a statute that's general in Texas about when attorney's fees can be collected under state law. Let's flip over here for a second and look at our complaint. This is the Jackson versus Frisco ISD complaint. We flip to the end here, near the end at least. We talked about conditions precedents, we talked about the cause of action, we talked about the damages, and now we're up to the attorney's fees. This is one of the statutes that varies from the American rule. And if Mr. Jackson is successful in his lawsuit, Frisco ISD will be required to pay him his reasonable attorney's fees. And of course, Frisco ISD will have to pay its own reasonable attorney's fees. But let's say for a second that Mr. Jackson isn't successful in his lawsuit. In that scenario, Mr. Jackson will have to pay his own legal bills, and Frisco ISD will have to pay its own legal bills. As you can see under the statute, Frisco ISD is always going to have to pay its own legal bills. The only thing that's at issue is whether Mr. Jackson will have to pay his own or not. And so that's how attorney's fees work. So this is a statute that provides this. This is not the American rule. This is one of those exceptions to the American rule. Okay, so here are some examples of situations in which you can collect your attorney's fees in Texas. One would be for breach of contract cases. Another is the DTPA cases. This is the Texas Deceptive Trade Practices Act. As far as I know, every state has one of these. And then civil rights laws. Again, the employment discrimination and other types of discrimination. These are examples of statutes that vary the American rule. Oops, sorry. Let me go back. I should have used this here. Sorry about that. Okay, so let's go forward. So you want to have a section in your complaint in which you talk about attorney's fees. Obviously, you want to have that if your client is eligible to have attorney's fees. Sometimes people stick it in their complaints even when there is not a statutory provision. It doesn't do any harm. Obviously, it's not that helpful either. But this is an example of the language that you might have in your section for attorney's fees. As a result of Bandon's breach of contract, again, that's one of those bases that we just talked about under Texas law, that the plaintiff would be eligible to collect attorney's fees. Justice has retained an attorney and seeks reimbursement of his reasonable attorney's fees as authorized by, and here is the actual statute. Let's go ahead and look at this statute just for a second. So it's, I think, helpful to, so we have here, we have the section, copy it, go over here. The way to find Texas statutes is Texas statute. I'm going to put a space here, Texas statutes. It'll be the first pull up with Google. Go to Essentially, this is paid for by our tax dollars, so there's no reason not to use it. I'm going to go to search. And I'm going to go to the Civil Practices and Remedies Code. Actually, I'm going to go back to home here. So I guess I meant Civil Practices and Remedies Code. And it looked like it was Chapter 38 is what I was looking for. Attorney's fees. And I'm going to press, and you can see here. So these are the circumstances in which one is entitled to collect attorney's fees. And you can see it's right here. An oral or written contract. So you can see here we have 38.001 and then in parentheses 8. And that's exactly what we've written in the complaint. Not in this one, I'm sorry, in the complaint that we were looking at here. Section 38.001 and then parentheses 8. It's always a good idea to cite the statute when you can cite it. This is not the correct Blue Book form for the statute. Again, we're not, this is not a Blue Booking course, and we're not going to focus on that. But you can see how it's helpful to know how that is related. Now, you may be thinking to yourself, wait a second, why is Groover pulling up Texas state law when we're in federal court? Well, in this particular case, let me go back and look. Let's go back to the jurisdictional section. Here we went too far. Here we go. This, the basis of the court having jurisdiction in the case that we're, the fictional case that we're covering in the PowerPoints is diversity jurisdiction. So the only reason that the federal court has jurisdiction is because the plaintiff and the defendant are citizens of different states and the amount in controversy is over $75,000. The gravamen, the cause of action is a state law claim, which ordinarily, obviously, would be resolved in state courts. When you're dealing with a state law claim, you have to look to the state law in order to figure out the parameters. A breach of contract case is a state law matter. And so even though we're in federal court, we would look to the Texas state law to address that issue. Now, let's say, though, that the contract was a contract that was established under the laws of Oklahoma. We're still in a Texas federal court. Which state do we look to under those circumstances? We would look to the Oklahoma state law. So it doesn't really matter what state you're in terms of federal court, in terms of the law that would apply. We would actually look at what laws determine that particular contract. Obviously, more commonly than not, if you're in a Texas federal court, either federal law or Texas state law is more likely to be in play, but it could be any state's law. Let's talk about the jury demand. Again, we already kind of talked about this. We talked about it being on the caption. If we want to have a jury demand and we're in the Eastern or Northern District, we're going to have the word jury in the caption of the case. Very likely, though, in addition to that, having that word jury in the caption of the case, we're also going to have a section in which we actually make the jury demand. Again, the term demand sounds kind of rude, but it really isn't. It's the normal term that people use for this. Now, the plaintiff is not required to request a jury trial. Certainly, the vast majority of plaintiffs do want a jury trial, but the plaintiff doesn't have to. There is a fee associated with that, so perhaps a plaintiff might say, well, I don't want to pay the fee. Okay, that's a possibility, but more likely the plaintiff has decided strategically that this is one of those unusual cases that it is not helpful for him to have a jury trial. And of course, if he chooses not to have a jury trial, if he doesn't make a jury demand, then he's going to have that bench trial. The judge is going to act as the jurors. Let's look at the deadline for making a jury demand, and we have it right here. It's Rule 38. So we're going to flip on over to the Federal Rules of Civil Procedure. Can we see here, Rule 38, right to a jury trial demand. Right reserved. The right of trial by jury is declared by the 7th Amendment to the Constitution, or as provided by federal statute, is preserved to the parties inviolate. demand. On any issue triable by right by a jury, a party may demand a jury trial by, number one, serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and filing the demand in accordance with Rule 5D. The most common way for the plaintiff to make a jury demand is in the complaint, but if the plaintiff forgets or for whatever reason wants to have a separate document, he can file the jury demand separately. Let's just go to Rule 5D so we can see what we're hearing there, what we're seeing there. Here's rule, this is about serving and filing pleadings in other paper. 5D, this is this section here. And basically this is just explaining how you file any document with the court. And this would apply obviously to a jury demand if it were its own standalone document. But that's pretty rare to actually have a separate document. So again, I said it's very common to have a section within the complaint in addition to it being in the caption. And here's the example. A justice asserts his rights under the 7th Amendment to the U.S. Constitution and demands, in accordance with Federal Rule Civil Procedure 38, a trial by jury on all issues. Oops. And then again, local rules sometimes require that it be in the caption, just so it's flagged for everyone to see. This is how we do this in the Eastern District of Texas. The word jury would be in the style. This is another important reason why you have to check the local rules. Some might have, some people might require that you type in the word spaghetti here. Obviously that would be silly, but you always have to make sure that just because we do it a certain way in the Eastern and the Northern District, it by no means follows it's done the same way elsewhere. Let's look to see how Jackson's attorney handled the issue of jury demand. And again, we have here a separate category, plaintiff demands a trial by jury. Well, let's go up here. There is no word jury here. I don't know if in 2012, maybe this rule wasn't in effect, or maybe he dropped the ball here. I can't say one way or the other, but obviously we don't have that word. But I guess a better practice, knowing what we know now, would be for him to have typed jury here. Okay, so now we're up to the prayer for relief section. This is typically at the very end. So at this point, let's go through the things that we've done. We've had the caption. We've talked about jurisdiction. We talked about the facts of the case and all the causes of action. We talked about the various remedies that we're seeking. And now we are up to the prayer for relief, which is, of course, tied to the remedies that we're seeking. Again, we talked before, prayer doesn't have a religious connotation in this situation. There's various ways of phrasing it. Again, there's kind of an old-fashioned way. Wherefore, premises considered, plaintiff asks for. You're welcome to stick with the old-fashioned terms if you want. Of course, it's not really a requirement, but it's not going to tick anybody off if you use the old-fashioned terms. And you're going to list all of the various equitable and legal relief that you're seeking. You're going to reiterate your attorney's fees request. You're going to seek pre-judgment and post-judgment interest and any court costs that you might be entitled to. You're basically relisting what you've already talked about, really. Let me pause here and talk about pre-judgment and post-judgment interest. Those are terms that you might not otherwise be familiar with. If you think about a lawsuit in the situation of a timeline, okay, so we have first of all an incident. So this is the event that happened that caused the lawsuit. And then we have the complaint is filed. And now we have the trial. And eventually we'll say we have an appeal. So pre-judgment interest is let's say at trial you are awarded, you're the plaintiff and you're awarded $100,000. Well, you are entitled to prejudgment interest. The judgment is the decision that happens at trial for all the way back to the event. This could be several years, and so 10% is a common number. I don't know the specific statute and then all the details of the statute, but you can see how $100,000 with a 10% interest rate over several years, that can make this number be significantly bigger. And then if the loser, in this case the defendant, chooses to file an appeal, there's going to be post-judgment interest up until the point where the matter is finally resolved on appeal. And this also can be several years. So during this time, there's going to be interest. This will be post-judgment, and this will be pre-judgment. Recoverable court costs, we'll talk more about this later on, but these are things like the cost of filing the lawsuit. There's a fee that the plaintiff pays for that. The cost of serving the lawsuit, deposition costs, jury fees, some other things associated with it. It does not include attorney's fees. It's usually, I would say, in the $10,000 to $20,000 range. So it's real money, but it's not anything along the lines of what attorney's fees are. And that's collectible. So this is, the loser has to pay for this. So this would be like the English rule, just with respect to court costs. So here's an example of a prayer for relief. Again, this is back to the mythical case of Buford T. Justice. For these reasons, Justice asks for judgment against Bannon the following: actual damages, attorney's fees, and again, you wouldn't say if applicable, prejudgment, post-judgment interest, court costs, and any other relief the court deems appropriate. This is a catch-all. This is, what if I missed something? What if I forgot something I should have included? Well, this is going to protect me. This is one of the benefits of working from a model. Even if your facts are very different, when you see something like that, you're like, oh yeah, I want to remember to include something like this in here. Here we have a discussion about prejudgment interest. This is a definition. Okay, after I was mistaken before, I apologize. It's not from the date of the event. So that's a little bit of an exaggeration, I'm sorry. It's from 100 days after the date the defendant received notice of the claim or the date the suit is filed. So it should have stopped here, most likely. But sometimes, if I sent a demand letter, if I'm the plaintiff, I sent a demand letter, it could be pushed back even, maybe 6 months after the date of the incident if I send the demand letter very quickly. And that might be another reason that you send an early demand letter. Okay, so not back to the incident, but back to the date of the complaint. Again, this is the state law requirement, so this assumes that we're suing under with a diversity basis for being in federal court. If you're suing under federal law, obviously the Texas law would not be applicable. The things that don't accrue interest are attorney's fees, and that makes sense because obviously the attorney's fees are growing over the course of the litigation. Also, court costs and punitive damages. Those are not subject to prejudgment interest. And apparently the cost is now 5%. That's on the low end right now. It's done based upon a calculation rate. And interest rates in the last several years have been very, very low. So let's just see if we can pull up here what the current rate is. It's probably still very low. Let's see if we can get it right here. Still 5%. And the interest type is simple interest. It's not compounded interest. Post-judgment obviously is until the date that it's paid, and it's going to be the same number as the prejudgment interest. But this is going to compound annually as opposed to just being a simple interest rate. Here we have a list of the recoverable court costs. And you can see the marshal fees, the clerk fees, deposition transcript fees, videotape depositions, docket fees, court-appointed experts and interpreters. It can be some real money, but it's certainly not a huge amount compared to the attorney's fees. And so this gives you a sense as to how to look at this. There's going to be lots of other expenses. Not all those expenses are going to be collectible. Okay, now we're up to the signature block. Before we go ahead, let's go back and look at the Jackson lawsuit. And here we have the conclusion and prayer. Mr. Jackson's attorney didn't start for the wherefore premises considered. Again, that's probably a better practice not to use that language. Plaintiff Alvin Jackson respectfully requests the defendant Frisco Independent School District be cited to appear and answer, and that upon final trial of this matter, the court enter judgment awarding Mr. Jackson. And here we have the list of things. Let's look at the list here. So we have back pay and front pay. These are statutory benefits. Compensatory damages, punitive damages, attorney's fees and expert fees. Again, this is statutory. Court costs, pre-judgment and post-judgment interest, and anything else the court deems proper. So again, this is the catch-all that we saw in the other document. So this looks like a pretty complete list. I think he did a good job. One thing that just statutory that is missing here would be reinstatement. That is an option under the law. But instead of reinstatement, Mr. Jackson is seeking front pay. It would be common in these cases to also list reinstatement. It can be a good negotiating position to use, but there's no particular reason it has to be included. It would just be common to have this included. And there could be other equitable relief that could be listed, such as requiring that there be training of the workforce at Frisco ISD about race discrimination or something along those lines. But again, every situation is different, and these are maybe things that Mr. Jackson did not want included in his lawsuit. Okay, so now we're ready for this. So we've talked about that we need a caption, we need jurisdictional information, we need the facts and legal theory. So those are our first three. And then we had to have our remedies that we were seeking. What was the relief we wanted? That was our fourth item. Now we're ready for the fifth item, which is the signature block. We talked also about a sixth item, the jury demand, but we decided that wasn't required, so it's not one of our five what we have to have. So this is our fifth item, our last required item for our complaint, and that is a signature block. Signature block is often called a subscription. Now, when I hear the term subscription, I think, newspaper subscription or a magazine subscription. But let's look at this carefully. Script means to sign, and sub means under. So to sign under. Well, that's exactly what we're doing in the signature block. We are signing at the end of the document. We're signing under the other content. This is the bottom, the last page. And so subscription really is the signature block statement. So if you kind of break the words apart and look at it from that standpoint, that means the same thing as the signature block. And we'll see the signature block just isn't the line where the attorney, or if the person is unrepresented, the individual actually signs. There's more going on there than just the signature. So let's see what we need to have. We need to have the signature of the attorney, or if it's not, that person's not represented by attorney, the actual unrepresented party's name. We need to have the address of the signer. So if it's the attorney who's signing it, we need his address. If it's the unrepresented party signing it, we need the unrepresented party's address. The email address, the phone number, and in our jurisdiction, we also need the facsimile and the attorney's state bar number. Let's look again at the local rules so we can see what is required there. Okay, let's see if I can get that to go back up. Here we go. So this would be under Rule 11. So we're going to go to page 15. So signing the pleadings. Every document filed must be signed by the lead attorney or by an attorney of record who has the permission of the lead attorney. So you can see the paralegal and no one else in the office can sign the pleadings other than an attorney. Request for postponement of trial must also be signed by the party making the request. Under the signature shall appear the attorney's individual name, state bar number, so again in the Eastern District we don't need the federal bar number, the office address including zip code, the phone and facsimile numbers, this is a local rule, and the email address. So again, you're going to want to go to local rules to see all the ins and outs of that. So here's an example of how it might look. We're going to go with respectfully submitted. A comma is more common here, but I've seen colons used. Sometimes people get confused on this one and they want to use respectfully submitted in the cover letter as well. Respectfully submitted is just for court papers. You don't want to use that in correspondence. You want to use very truly yours or sincerely yours. Those are really the ones that are appropriate. This format is nice. It's elegant. It's not the only way that you can do it. It's pretty common for the name of the law firm to be above the line, then to have a signature line, and to have the name of the attorney and his bar number below. But sometimes this, here, let me go ahead and, oops, let me go back. Sometimes this is actually put here. That's also fine. And this is a little bit of an old-fashioned way of doing it. What this setup is saying is it's really the law firm who is submitting this, but obviously the law firm itself, the partnership, can't sign anything. Only human beings can sign. So this is the designated person who is signing on behalf of the law firm. Then, of course, we have all of the data here, and you're typically going to conclude with, well, now what is this law firm's role in this matter? Oh, wait a second. Oh, they represent the plaintiff. Now, you can see in this case, only one attorney's name is listed here. It would not be unusual, though, to have another attorney's name and his or her bar number. You could even have several of those. That wouldn't be at all unusual. But you're going to have the lead attorney be the first name. And then, of course, this is how you do the e-signature fact. And again, you would go to the local rules. We'll look at local rule 5 to see how we do that. We go to local rule 5. Signatures. The user login and password required to submit documents to the electronic filing system serves as the filing user's signature on all electronic documents filed with the court. The name of the filing user under whose login and password the document is submitted must be preceded by either an image of the filing user's signature or as a \s typed in the space where the signature would otherwise appear. Okay, so going back here, we can see we have again that system in place. So this is a successfully executed block. This is a professional looking block. You want to have it, while it's fine in this case that they've did a little indentation, a little space here, but you really want to have this single space. It's not unusual for this to be in all caps or even to be in bold. This is a sharp looking setup. It's not the only way of doing it, but you know, appearances do matter. You don't want something that looks sloppy or that doesn't look professional. That's not the impression you're trying to make, obviously. Okay, so now let's look at how we did this, or how Jackson's attorney did this. Okay, we can see respectfully submitted. You can see it's filed electronically. We have the \s Joe Kendall. Joe Kendall's the lead attorney. We have his bar number. There are 2 other attorneys associated with it, Jamie McKee and Scott Kendall. We have their bar numbers, the Texas bar numbers. Here's the name of the law firm. So you can see in this case, instead of putting it up here, right below respectfully submitted, they put the name of the law group down here. See the street address, the zip code, we see the telephone number, facsimile number. What is missing is the email address. Now again, that may not have been part of the local rules back in 2012, and then you can see they have lawyers for plaintiff Alvin Jackson. So other than missing the email address, this looks like a well-presented signature block. And we are done. That is the end of this particular complaint. Let's go back and look and see the other things that we might have in a complaint. One thing that sometimes comes up, it's not very common, but sometimes comes up is you sometimes need a verification. And this is typically at the end of the document. And this is the page on which the person, and this is usually the client, he or she is swearing to the truthfulness of some facts in the complaint. This is required for certain types of complaint. Apparently this is required in this particular complaint. This is an example. So basically this is an affidavit, a verification. You're going to have it notarized. It's very common for paralegals to be notaries. Sometimes it's the receptionist or the legal secretary in the department, but oftentimes it's the notary, and so that can be another role that you have in the process. So we are good to go with our verification. As I said, we didn't need it in the Jackson case, that's why it was not present. Now, one thing that's missing from the complaint that we'll see in virtually all of the documents is a certificate of service. You may be thinking, where's a certificate of service? Well, you don't need a certificate of service in a complaint because it has to be served by a process server. You don't just stick this in the mail. That's not how you serve a lawsuit on a defendant. So that's the reason why we don't have a certificate of service in this case. So at this time, we're going to end this particular lecture. And when we get started in our next lecture, we will discuss some additional documents. Thank you for your attention.